Ms. Rahayu, Mahzam.
Mr. Speaker, I declare my interest as a lawyer in a private practice. Mr. Speaker, the obvious questions that arise in respect of this bill include: 1. Is the Criminal Law Temporary Provision Act, CLTPA, still necessary? 2. Does the Act and the extension of the same give the Minister of Home Affairs unfettered powers to detain a person? 3. Does this amendment seek to expand the Minister's powers further? The CLTPA provides the avenue to allow for the detention of persons involved in serious criminal activities where the normal criminal process is found not to be adequate or sufficiently robust to deal with them because of the threat of harm to witnesses or their families. Such situations would continue to occur as organized and syndicated crimes, as well as occurrence of violent crimes, continue to exist. We need to be able to deal with such situations effectively to maintain public safety, peace, and good order. Although the legislation grants powers to the Minister, these powers are circumscribed by its provisions. The proposed amendments seek to define these powers further. Firstly, Section 30 of the CLTPA provides for the Minister to make detention or police supervision orders if the Minister is satisfied that a person is associated with activities of a criminal nature. It is relevant to note that the Court of Appeal, in a much-quoted Tan Sit Eng case, said that it did not accept that the CLTPA has a loose or open-ended remit. The new fourth schedule will list the types of criminal activities in relation to which the Minister for Home Affairs can make orders for detention or police supervision under the above-mentioned Section 30. The list would make it clear to members of the public the specific criminal activities that the CLTPA can be used for. Secondly, the proposed amendments codifies the current case law on the finality of the Minister's decisions on detention and supervision orders. The Act is an executive regime, and the Court of Appeal in the Tan Sit Eng case has held that Parliament can decide to entrust the power to the Minister to establish the facts of a case, apply those facts to the relevant rules, and exercise his discretion accordingly. The finality clause that is proposed in this bill therefore reflects the Parliament's intent to entrust all relevant fact-finding powers under the Act to the Minister and clarifies the current position of the courts. The amendment put in statutes the common law position, which has been the position all along. What is important to re-emphasize is that the judicial review process is still available, and I therefore accept that there are safeguards in place to prevent unfettered use of these powers. Mr. Speaker, for the foregoing reasons, I support this motion.